Make a start. Welcome to our Data Protection Update webinar. I'm Sarah Williamson, partner and head of the commercial and technology team here at Boyce Turner, and I'm joined today by Lucy Cuthbert, a solicitor in my team.
Good morning, everyone, and thank you for joining us.
So in this webinar, we've got just under about 40 minutes to run through some of the changes that have occurred in the data protection arena during the course of this year, including the arrival of the new Data Use and Access Act. We'll also take a quick dive into the tricky topic of AI, but from a data protection standpoint only, and we'll look at some of the data protection requirements and how they apply to AI. We'll touch on the ICO's anonymization guidance and give an update on the position with regards to international data transfers. And then finally, we'll look at what might be coming down the road, which might be worthwhile keeping an eye out for. So whilst unfortunately we're unable to answer any questions that you may have during the webinar, there is a Q&A function, so please do send through any questions that you have and we'll endeavour to get back to you on these as soon as possible. So let's start by having a look at the Data Use and Access Act and some of the changes to UK data protection law that this will bring in. This isn't going to be a comprehensive summary of all of the changes given the time constraints, but more a highlight of some of the changes that are most likely to be relevant to the majority of private organisations.
The Data Use and Access Act, also known as the DUAA, received royal assent on the 19th of June 2025 and is currently being implemented via secondary legislation and regulations. This act follows a number of attempts to update data protection legislation, one of the aims of which was to reduce the perceived compliance burden on businesses. Whilst the act has not overhauled UK data protection law, it provides a series of changes which will affect businesses in the UK. The changes are limited and some of these will be welcomed by businesses as they bring some clarification. However, some new obligations may require businesses to change their internal policies and practices. At present, the government has not set out clear timelines specifying when all parts of the DUAA will come into force. Outside of changes to data subject access requests, the majority of the changes we will be discussing today have not yet come into force. Let's have a look at some of the changes under the Act.
So starting off with legitimate interests, there have been some changes that have been made regarding this. The DUAA has extended Article 6 of the GDPR, which sets out the legal basis to lawfully process data, by including a new legal basis for processing recognised legitimate interests. Processing will only be deemed to be necessary for the purposes of a recognised legitimate interest if it meets one of the conditions set out in the new Annex 1 to the UK GDPR. We've listed on the slide the limited circumstances that are considered to be a recognised legitimate interest, such as matters of national and public security. These are unlikely to be of much relevance for most businesses. The ICO is currently consulting on draft guidance regarding the recognised legitimate interest lawful basis, and the consultation remains open until 30th of October this year, if that is of interest. If processing falls under this new legal basis, organisations won't need to conduct a legitimate interest balancing test, assessing the benefits of processing the data against the impacts on the data subject. However, organisations must still ensure that the processing is necessary to achieve the required outcome. The change, which is perhaps more helpful for businesses, is a clarification of what may be considered legitimate interests for the purposes of the UK GDPR. Section 74 of the DUAA provides for a new Article 611 to be inserted into the UK GDPR, which includes examples of processing that may be processing necessary for the purposes of legitimate interest. Examples on the slide include processing which is necessary for direct marketing, for intragroup transmission of personal data, or for ensuring the security of network and information systems, all of which have been previously listed in the GDPR recitals. Just to be clear, any organisation relying on legitimate interests as opposed to recognised legitimate interests must still complete a legitimate interest balancing assessment. So next, moving on to data subject rights. The DUAA provides clarification of existing guidance for organisations responding to data subject access requests, essentially legislating what is currently set out in the ICO guidance. Following a data subject access request, organisations are only required to complete a reasonable and proportionate search, which is the currently enforced position under the UK GDPR in any case. Now, this is one of the few provisions that came into force on the date of royal assent, and it also applies retrospectively as coming into force on the 1st of January 2024. The DUAA also amends the time limit for responding to a data subject request, which must be before the end of the applicable time period, which is the latest of 1 month from when the controller receives the request, when the controller receives the information needed to verify a data subject's identity, and when the fee, if any is charged, is paid. Where further clarifying information is required from the data subject in order to respond to a request, the time clock is effectively paused. This is referred to as stopping the clock, until there has been enough time to obtain the relevant information and respond. There is a requirement on controllers to demonstrate that such clarification is reasonably required in order to respond to the request. And finally, the DUAA amends Article 13 of the UK GDPR so that organisations collecting data directly from the data subject will not be required to provide privacy information for further processing if the intention is to further process this personal data for research purposes, archiving in the public interest, or statistical purposes in accordance with Article 84B, which is a new article introduced by the DUAA setting out safeguards for research, archiving, or statistical purposes, and if providing the information would be impossible or disproportionate, for example, due to the number of data subjects. The Act also introduces a new right for data subjects to complain if they consider their information as being used in a way which does not comply with the law. Where necessary, organisations will be required to assist individuals in making such complaints. This includes providing the individual with means to complain, such as having electronic complaint forms. Following a formal complaint, acknowledgement must be sent within 30 days, and the outcome must be communicated to the complainant without undue delay.
Regarding automated decision-making, the Act softens the position, expanding the types of decision that can be made on a solely automated basis. It also limits the general prohibition against solely automated decisions in the UK GDPR to those decisions involving special categories of personal data, making it easier for automated decision-making to take place involving normal personal data. The DUAA also clarifies that solely means no meaningful human involvement, and that a significant decision is one which has a legal or similarly significant effect on the individual. These changes and clarifications are intended to make it easier for organisations to deploy AI while still protecting individuals. The DUAA also adds an additional Article 22D into the UK GDPR to enable secondary legislation to be brought in to provide clarity and define what is meant by meaningful human involvement, and a decision that has a similarly significant effect for the data subject. The ICO has declared its support for the changes regarding automated decision-making, recognising that it can bring benefits for people and organisations and increase efficiency. This is all part of encouraging innovation in the UK and driving growth, particularly for those areas involved in the emerging artificial intelligence technologies. Separately, the Act will amend the UK GDPR by clarifying the purpose limitation principle, i.e. the restriction against processing for a new purpose, which is not compatible with the original purpose. The Act introduces a list of purposes which are deemed compatible with the original purpose, which, including those which are in the public interest, such as disclosures to public authorities and safeguarding vulnerable people.
So taking a look at international data transfers next, the DUAA brings in a more risk-based approach to international data transfers. Article 45B introduces a new data protection test, amending the description of the standard of protection required under adequacy arrangements, which will now be referred to as transfers approved by regulations under Article 45A, and under alternative transfer mechanisms, now referred to as transfers subject to appropriate safeguards under Article 46. The data protection test assesses whether the third country or the international organisation in question has a standard of data protection which is not materially lower than that in the UK. When considering whether the data protection test is met, the Secretary of State is required to take into account a number of factors, such as respect for the rule of law and human rights, the existence and powers of an authority responsible for enforcing data subject rights, rules regarding redress for data subjects and regarding onward transfer of data, as well as international obligations and the constitution, tradition, and culture of the country or organisation in question. Now, whether the new test will be of benefit for organisations will likely depend upon whether the organisation is required to comply with both the EU GDPR and the UK GDPR. If it is required to comply with both, it will in any case need to demonstrate a standard of protection that is essentially equivalent to that in the EU GDPR in order to comply with the data transfer rules in the EU GDPR.
Regarding cookies, the Act amends Regulation 6 of the Privacy and Electronic Communications Regulations. Previously, organisations could not store or access information on a user's device unless it fell into one of the listed exceptions, including user consent or if this was strictly necessary. Without consent, therefore, cookies could only be used in very limited circumstances. The Act has added to the list of exceptions and permits cookies to be used in the following circumstances where the risk to the user is deemed to be low. Where information is collected for statistical purposes to improve the website or service provided, or where information is collected for the sole purpose of adapting the website appearance or functionality to reflect user preferences or otherwise enhance these factors, or to ascertain geographical position in order to deal with communications, which are requests for emergency assistance from a subscriber or user. Where cookies are used under the new low-risk purposes, organisations must still clearly and comprehensively inform users of the cookies at the outset and give users the option to opt out. Moving on, what changes has the DUAA made regarding data processing in the context of direct marketing? As previously mentioned, the Act confirms under law that legitimate interest may be used as a legal basis where processing is necessary for direct marketing purposes, subject to the carrying out of balancing assessment. Beyond this, the Act also clarifies the definitions of call and communication under data protection law, stating that these include all attempts to call or communicate, whether or not these result in contact with the recipient. Putting this into perspective, the definitions incorporate communications, for example, texts and emails, which are sent but not necessarily received. As a result, any organisation sending nuisance direct marketing, which never directly connects with the recipient, could be fined for causing harm or disturbance. The definition of direct marketing has also been widened to include the communication by whatever means of advertising or marketing material which is directed to particular individuals. The Act has also increased direct marketing fines under the Privacy and Electronic Communication Regulations to the same level as breaches under UK GDPR. This means for the most significant breaches, fines of up to the higher of 17.5 million or 4% of global turnover could apply. Moving on to changes made to the ICO by the DUAA. The Act renames the ICO to the Information Commission, abbreviated to the IC, and changes the structure to a body corporate, giving the IC a more typical UK regulator structure. The current Information Commissioner, John Edwards, will be the first chair of the IC when it comes into being, and this will continue in force for the duration of his original 5-year appointment as the Commissioner, which ends in January 2027. The Act also enforces a series of reporting duties on the IC, including annual reports on investigations undertaken and analysis of the IC's performance against key performance indicators. Alongside this, the IC will have increased enforcement powers, increasing their ability to review potential data breaches. This includes having the authority to compel individuals to attend interviews where it is suspected a breach of data protection laws has occurred. Finally, the DUAA also introduces a new power for the Secretary of State to add additional categories to the list of special category data under Article 9(1) of the GDPR. This is significant as to process special category data, in addition to having a lawful basis for processing, one of the listed conditions in Article 9.2 must also be met, such as explicit consent, or if processing is necessary to protect the vital interests of the data subject or another person where the data subject is physically or legally incapable of giving consent. The Act also allows for the Secretary of State to remove categories of special category data added under the new DUAA allowance, but not the pre-existing list set out under the GDPR. The justification for these changes was to allow the government to rapidly respond to future technological and societal developments.
So just before we move on to our next section, it's worth mentioning that following the Data Use and Access Act receiving royal assent, the ICO is updating its guidance on a number of topics across winter 2025-2026 in order to reflect the changes that will be brought in. Given that these are not radical, the updates are unlikely to be significant, but nonetheless worthwhile looking out for. So let's move on to our next topic today, which is the much talked about subject of artificial intelligence. At our in-person conference in May this year, we looked at the EU AI Act and the obligations and requirements of this regulation, which establishes a common legal framework for the development, marketing, and use of AI across EU member states. Whilst the EU AI Act and GDPR overlap in some ways, such as imposing requirements of fairness and transparency, the focus of the GDPR and other data protection laws is on the processing of individuals' personal data, whereas the EU AI Act focuses on the technologies and systems used for that processing. And therefore, it's important to always also remember data protection compliance when considering the development or deployment of any AI. Of course, at the moment in the UK, we don't have any specific regulation for AI as yet, with the UK wanting to adopt a pro-innovation approach. But a number of our existing laws and regulations are relevant to the development and use of AI, not least UK data protection laws. So today we're going to have a look at AI from a data protection perspective. And for the purposes of this talk, when we refer to AI, we're using the term to refer to a wide range of technologies, including machine learning, which in particular poses data protection challenges due to its reliance on huge quantities of data. So artificial intelligence is not new, but the use of AI technologies is undoubtedly growing and becoming part of our everyday lives and part of our social infrastructures. Many of these technologies process vast amounts of personal data. Personal data might be inputted into an AI system or could be the output of a system. Personal data might also be used to train an AI system or model. And whilst AI may provide benefits and opportunities, the use of personal data undoubtedly comes with risks. These risks can include the risk of discrimination. AI can produce discriminatory results and biases and predictions for many reasons, including the system being trained on data that is unbalanced. It excludes certain demographic groups, or due to the way in which the AI tool is designed or used. Another risk is the risk of a hallucination. There is the potential that where generative AI is unable to find the correct answer, that it may hallucinate or make up false information. And we've seen a number of incidents reported in the media of people, including very experienced lawyers, falling victim to AI hallucinations. From a data protection perspective, this is an issue, as one of the fundamental principles of data protection law is that personal data is accurate. There is also the risk of use of personal data without consent, or without an appropriate lawful basis, or for a purpose not known to the data subject. And some of these risks, including AI-driven discrimination, are set out in the ICO's strategic plan, ICO 25. So we haven't got time to look at all the data protection requirements and considerations. So we're going to look at one of the key data protection principles and what this means in an AI context. Article 5.1a UK GDPR states that personal data must be processed lawfully, fairly, and in a transparent manner in relation to the data subject. So starting with lawfulness, the processing of personal data in the development and or deployment of AI systems will involve numerous processing activities. And for each of these activities, there needs to be an appropriate lawful basis as required by Article 6 UK GDPR, all of which are on the slide, excluding, of course, the new recognised legitimate interest basis we mentioned earlier, as that's not yet in force. The ICO recommends separating the different phases, given that there are different and separate purposes for these with different risks, and it might not be possible to use the same basis for the different phases. For example, personal data might be used to train an AI system during its development, or might be used in the deployment of AI. Whilst the use of personal data for training purposes may not at that time affect the relevant data subjects, use in deployment might. It's also important to remember that if you're looking to deploy a third-party developed AI system, any lawful basis that the third party may have relied upon to develop the system may not be an appropriate basis to use for the deployment of the system. And further, different organizations may use the same AI system for different purposes. In terms of the options for a lawful basis, consent might be an appropriate basis, but there are limitations, not least the high bar for obtaining valid consent, which means that the individual needs to be fully informed, which could pose difficulty. It could be difficult for a complex AI system. Further, an individual always has the right to withdraw their consent, which might also pose difficulties. The performance of a contract lawful basis can only be used if the processing using AI is objectively necessary in order to provide the contractual service to the individual, or to take steps prior to entering into a contract at the individual's request. Whilst it might be possible to use this basis for processing personal data for the use of an AI system, it might be harder to use it for the initial development, and even harder for the future development of and improvements to an AI system. The compliance with a legal obligation basis may be appropriate in some circumstances, and in limited circumstances, processing of personal data by an AI system might rely on the protection of vital interest basis. For example, the processing of personal data for medical diagnosis, where a patient is unable to provide consent. But this basis would not be appropriate for the development of the AI system. Legitimate interest is, of course, the most flexible lawful basis, but it's important to bear in mind the requirement to carry out a legitimate interest assessment, which will involve identifying the interest, demonstrating that the processing is necessary to achieve that interest, and the emphasis there is on the word necessary, and balancing the interest against the individual's interests, rights, and freedoms. Where an AI system is being developed, this assessment needs to be reviewed regularly as purposes are further refined. So fairness, as required by Article 5, means that personal data should only be processed in ways that an individual would reasonably expect, and not in a way that is detrimental, unexpected, or misleading. An individual has both the right to non-discrimination as well as to privacy. Therefore, any processing of personal data using AI needs to avoid discrimination. Note that there may also be other sector-specific obligations around fairness that need to be complied with, and also bear in mind the obligations under the Equality Act as well. Accountability is a fundamental principle of the GDPR and requires organisations to not only take responsibility for data protection compliance, but to demonstrate compliance through documentation, policies, and procedures, and this is an ongoing requirement. The data protection implications of AI are dependent on specific use cases. Organisations are required to implement appropriate measures in the context of the particular circumstances, for example, the nature, scope, and context of the processing, as well as the risks to individuals' rights and freedoms. The ICO does state that it's not realistic to adopt a zero-tolerance approach to the risks to rights and freedoms, but instead the requirement is to identify, manage, and mitigate risks. The obligation to adopt a data protection by design and default assists in embedding data protection from the initial design stage right through the life cycle of an AI system. Data protection impact assessments are a key part of data protection by design and default, and provide the mechanism for assessing the risks that AI poses and demonstrating that processing is fair. A DPIA will often be required for the development and/or deployment of AI. Whilst the requirement for DPIA is where the processing of personal data is likely to result in high risk to individuals' rights and freedoms, Article 35(3)A UK GDPR requires a DPIA to be carried out in the case of a systematic and extensive evaluation of personal aspects relating to natural persons, which is based on automated processing, including profiling, and on which decisions are based that produce legal effects concerning the natural person or similarly significantly affect the natural person. processing on a large scale of special categories of data, or of data relating to criminal convictions and offences, or systematic monitoring of publicly accessible areas on a large scale. Now, whilst we don't have time to go into the full requirements for a DPIA, it is worth noting that the ICO states in its guidance that as part of a DPIA, an organisation should demonstrate that they have considered less risky alternatives to achieve the same purpose, and explain why they have not chosen to use those. Further, whilst recognising that AI often involves complex models and data sources, which makes it difficult to fully describe the extent of the data processing activity of an AI system, the ICO states that this is still a necessary part of a DPIA. As part of a DPIA, you need to consider the risks to the rights and freedoms of all individuals who might be affected by the AI system, and these risks may not be tangible damage. Remember also to consider the roles of each party when developing, marketing, or deploying any AI. And if you're working with a third party, you should also consider whether you are in fact joint controllers. The requirement for transparency means being clear, open, and honest with individuals about the processing of their data. Articles 13 and 14 set out the privacy information that must be provided to an individual, which includes the personal data being processed, the purpose for processing, who has access to the personal data, how long you'll retain the personal data for. In the context of AI, it's important to consider how and when this information will be provided to individuals. Guidance produced by the ICO and the Alan Turing Institute provides advice on how to explain the processes, services, and decisions made or assisted by AI, depending upon the audience. In terms of defining the purposes for processing, it is important to bear in mind that someone's personal data may be processed at different stages and for different purposes. As we've mentioned, personal data may be processed to train an AI model, and it may be processed in the use of the model and in the outputs. Each of the purposes need to be clearly defined, and there must be no function creep. The purpose limitation principle requires that personal data must be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with these purposes. This means that you can't collect personal data for one defined purpose and then use it for another undefined purpose, unless such new purpose is compatible with the original purpose, or you have consent for the new purpose, or there is a clear obligation in law. As mentioned earlier, under the DUAA, there are now exceptions to the purpose limitation principle, whereby organisations can process personal data for a new purpose in a manner which is compatible with the original purpose, but that's only for purposes of scientific or historical research, archiving in the public interest, or statistical purposes. Consideration also needs to be given to how a data subject will be able to exercise their rights. For example, training data may include personal data which might be amended within the AI system, such that it's difficult to link the data to a particular individual. However, data protection laws cannot be ignored, as it may still be possible to single out a data subject or to identify a data subject if the original data is used with other data that is processed. The ICO gives an example of training data used in a purchase prediction model, which includes a pattern or purchases by a particular customer. If the customer then provides a list of their recent purchases, it may be possible to identify the portion of training data that relates to that person. If an organisation does believe that an individual can no longer be identified from the data, it is their responsibility to prove this. Otherwise, they will need to fulfil any data subject request that is made. Now, there are, of course, other principles set out in Article 5, which should be remembered and that we've not mentioned, including the principle of data minimization. So you should not process more data than you need to achieve your purpose. So you can't simply just hold data in case it is of use in the future. And the principle of storage limitation. Data must not be kept for longer than is necessary to achieve the purpose for which it is processed. Both of these may prove to be challenging when processing data in an AI system. Data must also be accurate and kept up to date, which is particularly important when used to train models to avoid inaccurate inferences. Although note that an AI system does not need to be 100% statistically accurate to comply with the accuracy principle under the UK GDPR. Although where something is not intended to be regarded as factually correct, this should be made clear. And finally, we have the important security principle, which will apply to any processing of personal data and to all systems that you use for the processing. I would recommend taking a look at the ICO's guidance on AI and data protection, which is currently under review to take into consideration the changes to law contained in the Data Use and Access Act. It does contain some helpful guidance on compliance with data protection laws when deploying or using AI.
Moving on to anonymisation, in March this year, the ICO released updated guidance, acknowledging that anonymisation operates on a spectrum of identifiability with factors such as technical advancements, changing requirements. Recital 26 of the GDPR sets out the test for anonymisation. Organisations must investigate the reasonable likelihood of someone being identified from the data, taking into account linkability, i.e. whether an individual can be identified through multiple records, either across a single system or different systems, and/or singling out, i.e. testing if an individual can be singled out across records or isolated from a data set, and considering all objective factors. For example, the cost required to undertake such investigations by a third party, the time taken to identify, and available technology for identification attempts. All findings and assessments must be documented and checked against periodically. Alongside this, organisations must also undertake risk assessments from the perspective of a motivated intruder who is reasonably competent, has access to appropriate resources, for example, the internet, and uses investigative techniques. Crucially, anonymisation of data must be continually checked to ensure it remains anonymised as security and technology develop.
So one of the ICO's priorities, as set out in its ICO 25 strategic plan, is to enable international data flows through regulatory certainty. There is very often something going on in the world of international data transfers, and one of the concerns when looking to amend UK data protection laws was that the UK did not want to jeopardise its adequacy status with the EU for the transfer of personal data, which would certainly have had significant adverse effects on businesses both in the UK and the EU, and likely beyond. The EU has certainly been keeping a close eye on developments in the UK. The existing adequacy decision for the UK has been extended until 27th of December this year to allow for an assessment of the changes brought in by the Data Use and Access Act. That assessment has been ongoing, and since extending the adequacy decision, the European Commission has issued a draft implementing decision which determines that they will continue to assess the UK data protection standards as being essentially equivalent to those in the EU. As a result of that review, the Commission has proposed to renew the EU-UK adequacy decision for a period of 6 years. The draft implementation decision needs to be formally approved by representatives of the EU member states, and it's also subject to the non-binding opinion of the EDPB. In terms of data transfers to the US, this is something that is always under the spotlight, following numerous challenges, most notably from Max Schrems. We currently have the EU-US Data Privacy Framework, which allows for the transfer of personal data from the EU to those organisations certified under the framework. As it currently stands, for the purposes of transfers to the US under the UK GDPR, UK organisations are able to transfer personal data to certain US organisations under a UK-US data bridge without implementing any additional safeguards. These US organisations must be certified to the UK extension to the EU-US Data Privacy Framework. If the US organisation is not part of the framework, the UK organisation will need to continue to use one of the pre-existing safeguards, such as the often little used International Data Transfer Agreement, or the more commonly used UK addendum to the EU standard contractual clauses. There is, of course, also the obligation to carry out a transfer risk assessment. The ICO has recently set out their opinion of the UK extension to the framework, which outlines 4 specific areas of the UK extension that could pose risk to UK data subjects if the protections identified by them are not properly applied, which it stressed should be monitored by the Secretary of State to ensure that UK data subjects are afforded substantially similar protection in practice and that their rights are not undermined. These 4 risks are: the definition of sensitive information under the extension does not specify all the categories listed in Article 9 of the UK GDPR. There are no equivalent protections in the extension to those set out in the UK's Rehabilitation of Offenders Act 1974 in relation to criminal offence data. The extension does not give substantially similar rights to the UK GDPR with regards to data subjects being subject to decisions made from solely automated processing. And the extension does not give the same rights to data subjects in the UK GDPR, as they do not give them the right to be forgotten or to withdraw consent. Now, as mentioned, data transfers to the US are frequently beset with challenges, and the latest of which was a challenge by the French MP Philippe Platoon, who sought an annulment of the EU-US adequacy decision due to concerns regarding the legality of bulk data collection by the US and the redress mechanism. This challenge has recently failed following the European General Court making a landmark ruling on the 3rd of September 2025, finding that the framework was valid based on the facts and law at the time the adequacy decision was made in 2023. In view of the response of Max Schrems to the decision, it is unlikely that we will have heard the last of this latest challenge. And whilst at the moment the ruling means that the UK does not need to consider the validity of the UK to US data bridge extension, it is an area that needs to be kept under constant review and is subject to change. Now, just very quickly, we thought it might be helpful to also briefly mention the EU Data Act, considering the majority of its provisions apply from tomorrow. The EU Data Act harmonised rules on fair access to and use of data across all sectors of the EU, enabling more data to be available for use. We've listed on the slide who is within the scope of the Act, as well as its key provisions. Important changes include users having the right to obtain their data from the data holder, and the requirement for users to be able to easily switch cloud providers on short notice without obstacles. The aim of which is to promote competition and lower market entry for new providers, as well as prevent vendor lock-in. Alongside this, in recognition of the potential growth of the data economy and the growing prevalence of the Internet of Things, connected products will need to be designed and manufactured in a way that empowers users to easily and securely access, use, and share the generated data.
In this section, we'll briefly discuss key updates from the ICO over the last year. Firstly, the ICO's focus on online strategy. The ICO has identified that although users being tracked online can form part of their daily life, for example, allowing fitness devices to track user locations, this is a slippery slope where harm can easily be caused, especially in circumstances where users lack control. This is particularly a concern for the ICO within the advertising industry. The ICO have stated for 2025 that they are focused on exploring if the privacy and electronic communications regulations could be amended to assist an industry-wide shift towards a privacy-friendly form of advertising. The ICO plans to extend their action in this area, aiming to ensure users have meaningful control over how they are tracked for personalised advertising. The ICO have also provided updated guidance on consent or pay models. Importantly, there must be a way to access the site without consenting to sharing your personal data, for example, through payment. The bar for operating these schemes is high, however, and the ICO sets out key factors to assess model compliance against, such as power imbalance, appropriate fees, equivalence or core services, and privacy by design. Organisations must document assessments undertaken to ensure the scheme is fair, and individuals must always be able to withdraw their consent without detriment. Operating a take it or leave it approach, where individuals either consent or cannot access the site, is much more likely to be considered unfair. And finally, to close out the webinar, we thought it would be useful to look at what could be coming up. First, the ICO is planning to publish streamlined guidance for businesses developing or deploying AI. The ICO is looking to work with the government to embed these regulations into a statutory code of practice. Another area the ICO are due to publish updated guidance on is international data transfers, with the ambition of making it easier and quicker for businesses to safely transfer data. And then finally, as mentioned earlier in this session, the ICO are also looking at ways to ensure privacy-friendly online advertising.
And that brings us to the end of the webinar. So thank you to everyone for joining us today. We will be sending out a recording of the webinar, but in the meantime, if you have any queries or would like any assistance with the areas we discussed today, Or if indeed there are any topics you would like us to cover in future events, please do let us know and we will be happy to see how we can help. Also, if you're not already part of our in-house legal community and would like to join, please do get in touch. We've built a large community of in-house lawyers who we bring together at events throughout the year, such as virtual roundtables, webinars like this, and in-person seminars and conferences. Our next webinar is our popular annual contract law update for in-house lawyers on the 4th of December, run by my colleague Rowan Turrell, which again is free to attend. Further details are on the events page of our website, and we also have a page dedicated to our in-house community where you can catch up on the latest podcasts and webinars and see what events are coming up. So once again, thank you very much for joining us. I hope that you have a good rest of the day, and hopefully we will see you again at one of our future events. Goodbye.